Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. This case is short, but the legal principle it established is enormous. In contract law, timing is everything. If you send an acceptance by mail, is the deal done when you post it or when they receive it? Today, we're breaking down the 1818 case that changed how we look at communication and legal obligations forever. Before we look at the law, we have to look at the blunder that started it all. This case is a classic example of how a simple clerical error can lead to a massive legal dispute. In 1817, the defendants, Lindsell, offered to sell a quantity of wool to the plaintiffs, Adams. This wasn't a face-to-face deal. It was handled via the post, which was the standard long-distance communication method of the era. Understanding the medium used is the first step in assessing the legal risk of the transaction. The defendants accidentally misdirected the letter, sending it to the wrong county. Because of this administrative error, the offer reached the plaintiffs much later than intended. In modern terms, this is like a typo in an email address that delays a critical business quote. As soon as the plaintiffs received the offer, they posted their acceptance immediately. However, because the original offer was late, the defendants had already assumed the plaintiffs weren't interested and sold the wool to someone else. This creates a double sales conflict that courts have to resolve. The court had to decide exactly when a contract becomes binding, when parties are communicating across a distance. The core question was whether a meeting of the minds requires both parties to know about the acceptance at the exact same moment. If the law required the offerer to actually receive the letter before a contract existed, it could lead to an infinite loop of confirmations. This consensus addems as the foundation of any valid agreement. The court looked at whether the offer was still open when the plaintiffs mailed their reply. If you don't specify an expiration date in your offer, the law generally assumes it remains open for a reasonable time. Miscalculating this window is where many businesses face unexpected litigation costs. A major issue was who should bear the risk if a letter is delayed or lost. Should it be the person sending the acceptance or the person who initiated the deal? The court's decision effectively decides which party has to pay for the noise or errors in the communication channel. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. The court's ruling created one of the most famous exceptions in contract law, known as the Postal rule. The court held that the contract was formed the moment the plaintiffs put the acceptance letter in the mail. This is the Postal rule. It means the offerer is bound even before they know the offer has been accepted. This creates a period of blind liabilities for the person making the offer. The judges reasoned that if the rule were otherwise, no contract could ever be completed by post. The acceptor would need a confirmation of receipt, then the offerer would need a confirmation of that confirmation, and so on. To keep commerce moving, the law had to pick a definitive finish line. The court noted that the delay was the defendant's fault due to the misdirected letter. Because they started the chain of events with an error, they couldn't complain about the timing of the response. This highlights why accuracy in initial documentation is vital for avoiding breach of contract claims. While we rarely use letters for urgent business today, the principles of Adams v. Lindsell still apply to modern communication and risk management. Generally, the Postal rule doesn't apply to instantaneous communication like email or phone calls. For these, the receipt rule usually applies, meaning the contract is formed when the message is received. Mistakenly assuming the Postal rule applies to digital messages can lead to significant timing errors in high-stakes deals. One of the biggest hidden costs of the Postal rule is that you can't revoke an offer once the other party has posted their acceptance. Even if you haven't seen the mail yet, you're legally locked in. This is why businesses often use specific language to override this default rule. To avoid the risks of Adams v. Lindsell, savvy professionals include a clause stating that acceptance is only effective upon actual receipt. This moves the risk back to the person accepting the offer. It's a simple drafting step that can save thousands in litigation if a message goes missing. How should you handle offers and acceptances to stay safe? Here's a practical framework based on the lessons of 1818. Always specify the required method of acceptance. If you only want to be bound by an email, state that clearly. If you leave the method open, you might find yourself subject to the postal rule if the other party chooses to use the mail. Being specific reduces the chance of a court having to interpret your intent. Never leave an offer open indefinitely. Include a specific date and time for expiration. This prevents the reasonable time argument from being used against you in court. A clear deadline is the cheapest insurance policy against a delayed mail dispute. If you're the one accepting a high-value offer, don't just rely on the postal rule to protect you. Use tracked delivery or follow up with a digital confirmation. While the law might be on your side, proving you posted a letter can be difficult and expensive without a paper trail. That's the practical breakdown of Adams v. Lindsell. The big idea is that the law prioritizes commercial certainty, even if it means one party is bound before they know it. To protect yourself, always be clear about how and when an offer may want to be accepted. If this summary helped you understand the complexities of contract timing, subscribe to Law Conquer for more case breakdowns and legal education. We make the law clear so you can make smarter decisions. If this helped, please like the video too. Share this with the study group or anyone learning the law. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.